All right, let's proceed.
I'm Attorney Kwabena Boafe for the appellant Spencer Brooks Strings. Now, we're here today to discuss, in our view, three issues. Whether the 2009 amendments to the Massachusetts Conflict of Interest Law, in particular the enforcement provision, Section 21, still provides for a private right of action after the 2009 amendments. The second issue is whether the so-called regulated industry doctrine eliminates Mr. Leader's standing. And third, whether the competitive bidding statute, General Laws 30B, precludes an action under General Laws 268A.
Could I just ask as a factual matter, and maybe you've said this, did you, as I think you're entitled to under 30B, did you protest to the Attorney General?
We did not protest to the Attorney, well, we did not protest to the Attorney General, but from my reading of the...
I could be wrong about whether you can, but I take it that the Attorney General has certainly jurisdiction to enforce the bidding laws. So if you think something was unfair about the bid laws, it's a bid procedure, at least cases that we've had, people protest to the Attorney General.
There is a very, very interesting white paper by the Office of the Inspector General on this point. And what the Inspector General says is that there are no statutory provisions or regulations establishing an administrative procedure for bid protests, and you may proceed directly to the Superior Court.
But you didn't raise a third. Did you raise in your complaint? Is there?
There's a reason why we did not do that, and it is because during the application process to become a vendor in the Concord School District, we were actually told, or my client Paul Leader was told, that this was not a bid under 30B, that they were using these documents for vetting procedures, but this was not a 30B bid. Now, I see the quizzical, puzzled look on your face, and what I want to give you some facts that would back that claim up. Now, 30B requires that the file that's a matter of public record about the bid contains certain documents. It should contain the contract between the municipality and the vendor, and it should also contain a list of the criteria that were used to evaluate the person that was bidding and the rating system that was used to evaluate and record how this particular vendor matched up against the criteria. None of those documents appear in the public record on this. There's no contract between the Concord Public Schools and the vendor, and there are no there is a void of evaluative documents.
Was there going to be an expenditure of public funds?
No. The contracts are directly between the parents and the instrument rental vendor. So our position is that 30B here is a camouflage and a smokescreen, essentially, to mask the fact that there was an ethical violation.
But your client placed a bid, I take it.
Our client applied to be a vendor at this particular
But
school.
it responded to the request for proposals.
That is correct, in the context of being told that this was not a bid.
Okay, and if your client had won the bid, would your client have been content?
What we expected in this scenario, what we expect in all of the schools that we go into, is that similarly situated people will be allowed to compete for the business of the parents in the particular school district. That's what we just want, a chance to get the business of the parents in the school district. We don't want to force anyone else out.
But did you understand, or did your client understand that this was an exclusive access to parents?
It actually isn't quite exclusive, but you say it's pretty exclusive.
Well, it's interesting. What the winning person gets in this situation is an endorsement by the school, essentially, and they get to use public property, the school auditorium, as their auxiliary sales and distribution center.
But your client didn't bring an action for injunctive relief to stop this kind of thing from happening because it was unethical. Your client submitted a bid with the expectation or the hope that it would win that bid and get the benefit of all these things you've just described.
Well, in the record, there is a letter from the Ethics Commission written to a Mr. Andrew Braxton of the Parkway Public Schools, where he requests some advice about how a process like this should take place. And what the Ethics Commission, how the Ethics Commission responded to Mr. Braxton was that similarly, what the school should do is lay out certain criteria, and similarly situated people should be let in. So we followed the procedures that the Concord Public School laid out for us, but we were leaving it to the Concord Public Schools to behave in a way that was ethical.
Can we turn to 21 now?
Certainly, certainly.
I guess my question is, before one, it's sort of the argument that the State Ethics Commission makes in its amicus brief. Before one reaches the question of standing, there seem to be two condition precedents to filing a case. So let's assume you've got standing, but it seems as though, as defined by Section 21A, in order to bring a suit, you have to wait until the commission in an adjudicatory proceeding has done something, found something, and that the municipality has requested something to be done. So I don't see it as a standing question. I see it as a statute defining a right to sue, and you haven't, the conditions precedent haven't been satisfied.
That's an interesting question. And our view on that is that the Everett Town taxi case has not been, that holding has not been.
But the statute has been substantially and directly amended from the day that, from 1966.
Well, that's true, but nothing in the language of this amended Section 21A expressly precludes a private right of action. There's no express preclusion. Nothing in the 2009 legislative history, the Public Integrity Task Force report, nothing in that report evidences an intent to exclude a private right of action. In fact, in the record before you, we have an affidavit from the former Ethics Commission Executive Director, Peter Sturgis.
Who's sitting in the courtroom, right?
He is sitting in the courtroom. And at page A28 of the amicus brief filed by David Moynihan, you will see Mr. Sturgis's affidavit. And in that affidavit, he says he was a part of the commission that helped to redraft Section 21 and the entire conflict of interest statute at that. And the point of this was to expand municipal authority to deal with corruption, but not to take away from what this court had already decided in Everett Town Taxi. So one other argument in that point.
Could I just
Judge Arnold.
get you to back up a little bit for me? I'm trying to follow the process. If I understand you, you're saying that your client thought that they would have an opportunity to present their themselves to parents.
Correct.
Does that mean every person who replied to the RFP would have had an opportunity? If there were 100 vendors, 100 vendors would be given an opportunity to present something to parents?
Normally, that's the case. So I've represented Spencer Brooks Strings and Paul Leader since 2005. And it's normally the case that if you are similarly situated, everybody's selling the same quality violins, you are permitted to attend an instrument rental night where you get to meet and greet with the parents and sell your instruments. Different people decide similarly situated differently, or rather different school districts.
But this system picked what they considered to be the best option, and they gave them an pretty much exclusive opportunity with the parents, right?
Well, in terms of what the documents actually say, that's not necessarily clear. What happens after the school district makes its decision is that we then see an endorsement letter on school letterhead with Music and Arts' logo saying they will give you quality instruments, but we can't vouch for anyone else giving you quality instruments. So what we knew was that we were following the procedure that the school district set out. We would have hoped that the school district would follow the ethical statutes and allow similarly situated people the opportunity to meet and greet parents on public property. What happened after the school district made its decision, we weren't a part of that. But what we did was follow the procedure that the school district set out. And as it turned out, the result of that procedure was what we thought an unlawful endorsement and this exclusive arrangement where the school district gets nothing in return, pays nothing, but Music and Arts gets this use of public resources, including the time and talent of public administrators to process returns, facilitate exchanges, and distribute the instruments. And our main point here is that citizens in this Commonwealth, small businesses in this Commonwealth, should have the ability to decide how they're going to market and who they're going to market to and do business with each other without being encumbered by the state endorsing one product over another.
Let me ask you this. Before the 2009 amendment, is it your position that there was a private right of action under Section 23 of 268A? In other words, for a violation of Section 23, that there was a private right of action before the 2009 amendment?
That is an interesting question, and honestly something I had not thought about until you just asked the question. But thinking about it now on my feet, what I would say is that if we were looking at the statute as a whole and trying to effectuate the statutory purpose, I would think that there is a rationale and a way that you can get there. Because if the
21A and 21B didn't provide such a right of action. It didn't reference Section 23 at all.
That is true. That is true. But, and I'm taking a slight risk saying this, but if you look at the Everettown taxi case, there is not a specific, Section 21A is mentioned as from an enforcement perspective. But what the court relied on, whether it was Section 19 or another section, is not actually explicitly referenced.
Well, I'm not going to remember precisely, but the conduct being complained about there was under one of the sections that was at the time mentioned in Section 21A.
You could presume that it was Section 19,
19, that's
from
exactly
the
right.
context.
Yes,
You are correct, Justice. But what I think is important is the facts as they stand now, and not what the court would have done with this case prior to 2009.
Except that if there was no right of action before 2009, no private right of action to seek enforcement of Section 23, then we would have to conclude that somehow the 2009 amendment created a private right of action, and it surely doesn't seem to do that.
Well, I would disagree, and the reason why I disagree is because when we look at the 2009 task force report and the press release from Governor Patrick in, I believe, January of 2009, announcing this task force report. The governor and the task force report specifically say that the point of this is to expand enforcement.
But isn't that expanding the commission's enforcement?
Well, to expand effectiveness. In addition, I'll add this, and I see that my time is up, but the 1962 report in this respect said that enforcement of this statute must be realistic. Now, if we expect for municipalities to police themselves and ask the commission, we've done something wrong, please have an adjudicatory proceeding to penalize us, that is simply not realistic. So if we want to effectuate the intent of the legislature here, who says that enforcement means need to be realistic, then it makes sense for private people who in some cases are in the best position to provide a vehicle for enforcement to have that right.
Thank you, counsel.
Thank you, Judge.
May it please the Court, Adam Sims for the Concord Public School Department and the individual defendants as well, all school officials. Justice Spina, let me answer your question directly. I don't think anyone here can possibly doubt if Spencer Brook Strings was the winning bidder, none of us would be here hearing this argument today.
Could you talk about the 30B, whether it does or doesn't apply?
The white paper that counsel referred to a moment ago, I have a copy with me, issued by the Inspector General's office, specifically says, and this is in the papers that we submitted to the Superior Court, who pays is irrelevant to whether a contract is subject to Chapter 30B. It then uses an example. For example, a yearbook contract awarded by school officials falls under the law, even though parents or students will pay for the yearbooks. Strikes me that there's no difference than in this setting.
Did your client, meaning the school district now, not your individual clients, but was part of this process explaining to the potential bidders this really isn't a 30B situation?
Well, I have to answer it this way, Justice Botsford. The initial document was the publication published by the Secretary of State, indicating that we're going to be sending out an invitation for bid. That's the language used. The invitation for bid that's in the record follows and includes all of the requirements of Chapter 30B, all of the language that talks about lowest price and responsive and responsible bidder.
And the goal of this contract, as I looked at that briefly, what I take it is to lock, it's to secure a set price for the rental of these instruments to the families.
That's correct, Your Honor. Again, with the most responsive and responsible bidder. And, again, turning to a question you asked at the outset, Justice Botsford, no. There was no protest of any kind filed by Spencer Brook Strings, either with the Attorney General's office or with the Inspector General's office.
So what makes it a 30B bid? Is it because there was going to be like free rent at the school department for an exposition, that type of thing? Or?
Well, I think, Your Honor, what the Assistant Superintendent, Mr. Flaherty, had in mind, and this is explained somewhat in his affidavit, one, the dollar value of the contract. I mean, this was over $5,000.
But the city wasn't paying anything.
The school department does not pay for the services. That's correct. And so I think, if anything, I mean, the notion of whether this had to be promulgated under 30B versus doing the right thing and going out to bid, I mean, that's sort of faulting the school department for doing the right thing instead of, or versus someone, whether it's the assistant superintendent or someone else in the program, simply saying, I like X company, that's who we're going to use, and not sending it out for bid. So I hate to use colloquialisms, but no good deed goes unpunished. That seems to be what I'm hearing as part of the plaintiff's argument here.
But what is the need that there be just one vendor? It had not always been that way.
And that's true, Your Honor. And there still is not only one vendor. As we pointed out in our papers, this is not an exclusive contract.
But there's an endorsement by the school of one vendor.
They're loosely, very loosely, I'll concede there's
What was
an
the bid
endorsement.
for, I suppose, is another way of putting it. What was it a bid for?
It was a bid-
Favored nation status?
Well, you get to be the
Akin to that, Your Honor, which is precisely spelled out in the invitation for bid, which Spencer Brook Strings participated in, Your Honor, not once but twice. In fact,
Well, how else could it be considered even among the people, among the vendors who could solicit parents if it didn't comply with the school's set procedure?
that's fine that they did, Your Honor. My point is,
No, my point is there a way that they could have participated on school grounds had they not participated in this bidding process?
well,
Would they be allowed in to solicit parents on instrument night or whatever it's called?
the school has not had, did not have an instrument night this year, meaning this school year. What they did do, and to be candid, last spring, they had a music introduction night. My understanding is that that was sort of an introduction to parents whose students may be interested in the music program. And
was M&A the only vendor at that introduction to music night?
M&A was the only vendor at that music night, but I was not there, but I'm told by Kathy Cordione, who sort of runs the whole program, that she said repeatedly to the audience, this is not the school's preferred vendor. And any of the parents who want to use any other vendors or purchase your equipment on eBay or Craigslist or whatever are free to do so. And that's what the school department has done in the last 2 years.
Could SBS have shown up at that event and set up a table and presented its wares for availability to parents?
I don't know if they could have at that night, Your Honor, but I do know this. One thing they still are allowed to do, which they continue to do, the repairs. SBS is not treated any differently than music and arts in that regard, which I know is one of the real concerns, at least raised in the brief. If Spencer Brook Springs drops off an instrument for a student, if the school department has a string or maybe the chin clip for a violin, if it has that part, the school department will provide that even though it's a rental from someone other than music and arts. They do the same thing in terms of repairs. Likewise, if a student or a parent drops off some equipment and indicates to the proper official, basically signing in, Spencer Brook Springs will be coming later to pick it up, to make the repairs, no problem. So in that regard, there's no difference in treatment. So I'd like to get back to the question Your Honor raised about the conditions precedent.
Yep.
If this court accepts the view of the State Ethics Commission as described in its amicus brief, and I would suggest that this court has said, you know, its opinion is entitled to considerable leeway, I believe is the language this court has used, then the inquiry ends that there's no private right of action under the circumstances of this case under Section 21, 268A, Section 21.
So, and what do you say to the argument that has been made that that sort of the spirit of Everett Town Taxi is that if we're going to make this law effective, a private right of action needs to be recognized, and one view of the, I take it, I'm paraphrasing the argument, but certainly one view of the legislative history of the 2009 amendments was that there was no intent to change that.
Well, Your Honor, I think two things. One, if you look at the actual language of Section 21A, B, there's a provision that was added in the 209 amendments.
21B or 21A?
Section 21, B, little b.
Yeah, okay.
And one of the things that the Ethics Commission now has the power to do, or this language was specifically added, is when it issues some order, whether it's a cease and desist order or an order requiring the offending entity, in this case, pay some money, one of the things it considers is requiring the violator to make restitution to an injured third party. Well, I think that's very important. That suggests to me that the legislature specifically included in the power vested in this Ethics Commission precisely what we're talking about here. Now, bear in mind that, as we pointed out, Spencer Brook Springs did avail itself of the right to file a complaint with the Ethics Commission. In October 2011, the school department received a request to provide the IFB and all the bid responses to the Ethics Commission, which the school department did. Now, I can't say for 100% certainty that was initiated or precipitated by a complaint from Spencer Brook Springs, but I think that's a pretty logical assumption. And the school department still has not heard from the Ethics Commission. So for all the school department knows, that may still be under investigation with the Ethics Commission. The second thing I would say to that, your answer is, our firm does an awful lot of municipal work, both on the town side and the school side. And it's simply not true to say that when the Board of Selectmen, for example, becomes aware of some problem with one of the officials it appoints, particularly department heads, that a Board of Selectmen virtually never takes action to see that it's corrected. In fact, that power is also in Chapter 268A. I think that was discussed somewhat in this Court's opinion a year ago involving Charles Turner.
Yeah. But I take it you might respond as well that even if under 21A the municipality wasn't going to do anything, the amended version of 21B gives the Ethics Commission itself power to say, sorry, municipality, I'm not waiting for you. We're going to move in here.
Yes, Your Honor. And I think it's made emphatic in 21B. It's reinforced in 21C, which references the additional powers that the Ethics Commission has under Chapter 268B, Section 4J. And both of those read together vest investigative and prosecutorial authority in the Ethics Commission in the Attorney General's office. For the legislature to have, as recently as 2009, as Justice Cordy says, substantially revised the statute and nowhere made any mention of a private right of action, expressly anyway.
Well, it didn't take it away either. It just, it seems to me, created a funnel that these things have to go through the commission in the first instance.
That's correct, Your Honor, and that's our position, and that's the position of the Ethics Commission, which at least is procedurally, some complaint still sits with the Ethics Commission, which may or may not still be under investigation. But in any event, the second prong of 21A, the school department has not requested that this action be pursued. In fact, the school department obviously opposes allowing a private right of action to go forward here.
Now, is it your view that that language of request means that only the school committee could bring the action, or could it request a private person to bring the action? Which is a question of whether it's a condition precedent or a standing.
Well, the language of the statute is upon request of the municipal agency on such terms as the interest of the municipality and innocent third persons require. I suppose if this, in this instance, the school committee voted, a majority vote, to delegate that sort of authority to a private party, then the private party would be, in essence, standing in the shoes of the school committee for purposes of pursuing the private right of action. And likewise, if it were on the town side, if a Board of Selectmen were to vote similarly.
Well, I think actually, I mean, it's possible that the municipality could request the Ethics Commission, and then once that was done, somebody could just decide to bring a suit, I think.
I'm not sure I follow that, Your
Well,
Honor.
I guess as I'm just sort of reading the language, this will be grounds for rescinding, canceling, et cetera, on request of the municipal agency, but it doesn't necessarily mean that, once that request is made, I don't read that as necessarily requiring also that the municipality request the private person to bring the suit.
No, I didn't mean to
Yeah.
suggest that, Your Honor. And one of the other things that my brother mentioned is sort of the overarching public policy argument. Well, there's another part of that which I do want to mention. Again, the Ethics Commission raised it in its brief, that they received over 1,400 complaints last year involving public officials, they being the Ethics Commission. And obviously, I don't know how many were under Section 21 or Section 19 or what section. But if this court is going to allow a private right of action in the facts and circumstances of a case like this, where there are no allegations of favoritism or nepotism or political favoritism by the authority that awarded the contract, then I think it is safe to say the superior courts will be deluged with persons who, like Spencer Brooks Springs, were nothing more than the losing bidder. And that's what this case is all about. They lost the bid.
Now, in terms of the record, I gather, is there anything in the record that reflects how much this is costing the town to defend?
There's nothing in the record about that, Your Honor. No.
All right, thank you, counsel.
Thank you, Your Honor.